This is OPE review of property, looking at covenants. Run with the land, you must have notice. Covenant must touch and concern the land, and there must be intent to run. Touch and concern look to benefit to other landowners in use and or enjoyment. Looking at the land sale contract, marketable title is an implied covenant in a land sale contract, and the seller has a duty to deliver marketable title. Easements affect marketability of title. Marketable title is for the benefit of the buyer, and the buyer may waive the right to marketable title. Marketable title or title obtained by adverse possession is not marketable, and quitclaim deeds or deed creates no warranties of title. Land sale contract and the risk of loss, where the contract is in place but silent as to risk of loss and no statute. The buyer has equitable title, so the risk goes to the buyer. Now, where facts state the seller would prevail, the principle here that they're relying on is the principle of equitable conversion, and this applies the risk of loss to the buyer. Now, equitable conversion, a little more about that, is where a contract is in place and capable of specific performance and silent as to risk. The buyer then has equitable title. So the contract's in place, capable of specific performance. The buyer then has equitable title. Risk of loss, we said there's silent as to risk. The contract is in place and silent as to risk of loss, and there's no statute. Buyer's equitable title, buyer risk passes to buyer. However, where there is a statute, one statute may be the Uniform Vendor and Purchaser Act. This places the risk of loss on the party in possession. Land sale contract and the duty to insure, where the contract is silent on the duty, then neither party has the duty. Land sale contract and the doctrine of merger. Title merges with deed at delivery. It can no longer sue on title matters contained in the contract of sale after the deed is delivered and accepted. Again, doctrine of merger. Title and deed merge at delivery. Can no longer sue on title matters contained in the contract of sale after the deed is delivered and accepted. A contract action would be wrong. The best option would be an action regarding the deed. Looking at a deed and validity of the deed, and for a land sale contract, it's valid if it's delivered. It need not be recorded. Delivery is a question of intent to pass dominion and control and immediately transfer title at delivery. If there's no immediate transfer of title, then there is no delivery, such as you can hand it to the person and you lose title to it there. Land sale contract and the statute of frauds. Time for performance. If it's not required to be specified in a contract for sale of real property, the court will infer that performance within a reasonable time was intended. Looking at property and condemnation. It's a partial condemnation. The landowner and tenant relationship continues. The tenant must pay rent for the entire portion. However, the tenant is entitled to share condemnation award to extent it affects their rights. Okay, easements, a commercial easement, it's not tied to a parcel, but granted. It may always be transferred, and permission of the servient estate is not needed. Again, commercial easement, not tied to a parcel, but granted, may always be transferred, permission of servient estate not needed. Equitable easement, aka irrevocable license. Here, no writing is required. It may be provided orally. Most jurisdictions, unconditional right to use land following an oral license, provided party expended money and labor in reliance on the license. Looking at mortgage liability. You have a purchase money mortgage. If that purchase money mortgage is executed at the same time as the purchase, it is primary to any other claim and or lien, including previously filed judgment liens. Mortgage liability and conveyance. If the estate is hindered by the mortgage, a life tenant, looking at the obligations of the life tenant and the remainderman, the remainderman is liable for mortgage to protect future interest. So somebody dies, leaves their spouse a life estate or somebody else a life estate, and then to a remainderman, that life estate holder is not liable for the mortgage, the remainderman is. Mortgage liability, notice jurisdiction. An innocent purchaser for value without notice takes free and clear of any unrecorded interests. Now you have constructive notice that's met when the mortgage is recorded. You have possession notice. This is not met if the lot is vacant. Mortgage liability and deficiency of the mortgage. If it is an assumption, the party who assumes becomes primarily liable. The original mortgagor, the borrower, is still secondarily liable absent a release from a bank. Now, mortgage liability deficiency, where it is a transfer, quote, subject to, the party who takes a property, quote, subject to, end quote, a mortgage is not liable for the mortgage. However, the original mortgagor is still primarily solely liable. Mortgage liability in the due on sale clause. It's not an illegal restraint on alienation. This is where you must have bank consent to transfer. An installment land contract is a transfer and can trigger the due on sale clause. Mortgage liability and foreclosure. You have an equitable right of redemption. This arises prior to foreclosure. After default, you can bring the mortgage current and have title restored. So foreclosure, equitable right of redemption prior to foreclosure. Now foreclosure and the statutory right of redemption, this is a right provided by statute, obviously, applies only after foreclosure sale. You may pay the sum at the foreclosure sale and recover title from whoever won the title. Mortgage liability and the doctrine of exoneration. When the testator dies, property is conveyed subject to the mortgage. Mortgage is paid out of the residue. Estoppel by deed. This validates a deed, example, a warranty deed, executed and delivered by a grantor who had no title to land at a time, but represented they did, and did in fact thereafter acquire such title. This stops the grantor from later claiming ownership. The rule against perpetuity. Now, any interest that reverts to the grantor is not subject to the rule against perpetuity. The doctrine of Cypress does not apply to conveyances. The doctrine of Cypress does not apply to conveyances. Only applies to general charitable intent. We got lapse. This is where a beneficiary predeceases a testator. No provision dictating what happens to property in question. There is then a lapse in the conveyance. The property passes through the residuary clause of the will. Land disputes, you have a partition. You have a partition in kind and a partition by sale. The partition action is brought by a tenant in common. Partition in kind is preferred. This is a physical division. Now, partition by sale is allowed where fair division is impossible, such as where a zoning ordinance would make division by portions unfair by making one portion useless. Landlord and tenant issues. Where a vicious animal is owned by the tenant, landlord owes no duty unless they know of the animal's vicious propensity. Then they only have a duty to take reasonable precautions. Landlord and tenant, in the absence of a rule stating the landlord must put tenant in actual possession, all the landlord must do is put tenant in legal possession. Generally, they have to put them in physical and legal possession. But in the absence of a rule stating the landlord must put the tenant in actual possession, they need only get legal possession, meaning the lease. Joint tenancy. A lien against one tenant does not sever the tenancy. And a judgment must be executed during the life of that tenant against whom the lien is obtained. The lien is vanquished at death of that tenant, and remaining tenant with right of survivorship takes the tenancy, sole ownership free of the lien. And that completes OPE review of property.